morning everyone, I'm Janus, Olivier. I'm an attorney here at Velden-Duffey Attorneys. With me is Elmari Richter. She's also an attorney and the head of our family law department. So we are discussing an email today which we received about matrimonial property regimes, the big whole out of community of property thing. Of course, that's why I have Elmari here and myself. I'm a notary, so I draft the ante-nuptial contracts every now and then. So the email that we got says, "Hi, my boyfriend and I recently got engaged. They started planning a wedding. Parents say that if you don't marry in community of property, it's not for love. And the broker says that is a bad idea to get married in community of property." So she's asking, I was hoping you could provide us with some advice about what the consequences of these marital regimes are and which one we should choose, firstly. And then she's also saying, we heard that you can get married with the accrual system, but aren't sure what it means. Is it some sort of halfway between in and out of community of property? And the email is ended very nicely with sincerely. So dear Anonymous, let's see if we can help you. The way I always used to explain to my clients is that in the most simplest form, you get in and out of community of property. In community of property, there's one joint estate. I always tell my clients, I cannot say this bank account is yours, this bank account is yours. Even if you have the husband who has received only his salary in one bank account for his whole life. If you are married in community of property, that is not his bank account. It's everyone. So there's one joint estate and it's indivisible.
And you share everything, even the assets or debts that you had before getting married.
Exactly.
Once you get married in community of property, everything that you had before your marriage, you now share with this new spouse. Everything that you will build in this marriage, you also share with the spouse. 50-50, equal share.
Yeah, and that's often where the argument for love comes in, because why wouldn't you want to share in everything you claim to be in love? So, yeah, there is some truth to that, but with the accrual system, I believe you can counter that argument or get the exact same thing. You always also share in most of everything. You can agree what to share on, but then the out of community of property, effectively, there's no joint estate. That's all that it is. You stay separate. Myself and Elmari, we have separate estates now. If we, for example, were to get married out of community of property, nothing would change effectively. What's mine is mine. Whether I get it during the marriage or after the marriage, it's mine. Or during the marriage or before the marriage, it stays mine. Except now with the accrual claim, but we will get to that, right? I mean,
yes,
that I got that right.
And there's a lot of protection in getting married out of community of property because you stay this individual in a legal sense. There's protection from creditors and you can continue to contract the way you please. When, let's take in community of property, then you always need your spouse's consent. You cannot buy a car, a house, or enter into any agreement without the spouse's consent. Wherein if you get married out of community of property, you stay an individual, like I said, in the legal sense. And you can then contract the way you please. Everything you own belongs to you solely, and that's how you carry on with your life. I just think that we should focus on the accrual a bit, because I noted that people do not really understand the accrual system. Now, the accrual system is set in place to keep you married out of community of property. So I think that's our first focus. When you get married with the accrual, you're still married out of community of property. But the accrual is a sharing format, I want to call it, that only comes to play at a divorce or when one of the spouses pass away. So I think you should go into a bit more detail with the accrual. Maybe explain to everyone what's your opinion in respect of the accrual as well.
So the accrual, in my opinion, is aimed at giving the same benefit that you would have with community of property, so that you can share in the growth of the estate. So accrual basically means the growth of your estate. What was your accrual during the marriage? So that's important. So as Elmari said, whether the marriage ends by way of death or divorce, that is only when the accrual becomes effective. Until then, you just made it out of community. So accrual means a calculation will have to be made once the marriage is at the stage of being dissolved to calculate your growth, and then the party whose estate had the smallest growth or the smallest accrual, then he is entitled to the accrual claim. What is the value of the accrual claim? It's 50% of the amount by which the other party's estate grew more during the marriage. So by way of an example, let's stick to me and Elmari getting married hypothetically. We both have nothing, so we have zero when we enter into the marriage. Now, a year from now, Elmari has 2 million rand, whether that is in cars, assets, anything, and I have 1 million rand. So her estate grew more during the marriage, and it grew more by 1 million rand. So 50% of that is 500,000. Now I have the accrued claim for 500,000. Once I have that in my name, I now am on 1.5 and she's on 1.5. So that's what I said. It aims at giving you the same benefit.
Leaving the parties on equal footing.
Yes.
I just want to mention here, before we get into the exclusions and the commencement value of the accrual. The accrual is not an asset share. It's a value share.
Exactly.
So we determine only the value of the growth. So let's say, for example, we are married, and when at the time of the dissolution of our marriage, be it death or divorce, neither one of our estates has shown any growth. So, for example, I'm on 2 million, you are on 2 million. Then we walk out with our own 2 million. There's no share in any asset. I cannot say, but no, I have a 50% share in respect of the house, and you have a 50% share in respect of my car. There's no such sharing. It's only, you only share if there's a growth. So if Janus's estate has grown more than mine, we share in the difference of the growth. And then, like I said, we share in the value. For example, a 500,000 or whatever the case may be. We do not share in an asset. The asset remains the asset of the party, and that the crux there is because the parties are still married out of community.
I want to jump onto this point, and it's an important distinction that you're mentioning, because as you said, if we both on 2 million at the end of our marriage, parties are, well, individuals are under the misconception that we married with the accrual, so I must share in my estate, so you get 50% of my property and I get 50%, I still have 2 million. That's not the case. No. Then you're back to in community of property. Yes. So even though I said it's to give you the same benefit, it's a monetary value. So if you have 2 million, I have to we keep it separate. Yes. I agree. That's
there
important.
There will only be a benefit if there's a growth. If there's no growth, no benefit.
That's important. So please remember that, Elmari. Then you mentioned on the beginning value. So that's another important aspect. I mentioned in my example, she ends on 2 million, I end on 1 million. But now, in my ante-nuptial contract, your notary states, but at date of concluding the marriage, Elmari already had 1.5 million. I still had nothing. Now, a year from now, same example, she has 2 million, I have 1 million. So even though my estate is smaller than hers, my accrual during the marriage was actually more than hers. So now I would need to pay her, well, she will have the accrual claim. So 50% of that would now go back to Elmari. So it isn't always going to be that you walk out with exactly the same values at the end of the day. It depends on what was your beginning values. For most of my younger clients, I would say just make your beginning value 0. And the effect of that would be that you share in everything.
If you don't have any assets.
Yeah, any substantial assets.
Yes.
Of course, if you are now 40 or 50 and you have went through life, you've gained assets, of course, add your beginning values. If you're a younger client, you're of course welcome to do that. But it often, I can see there's someone 30 and the clients are sort of, I don't want to mention my car now because I feel my potential spouse is going to think, oh, I don't want him to get anything. So it's once again that issue of love or not love. So normally both parties have a car or both parties have some sort of asset. So there's not really a bigger difference. So if I mention my beginning value as 1 million and Elmari mentions her beginning value as 1 million, the effect is 0. So then it's not necessary to say, but what does my million consist of? If we have the same million, it doesn't matter. We can then make it 0 or make it 1 million. The next thing, Elmari, I'm not sure if you want to, you can exclude specific assets as well. So if you, for example, are the beneficiary of a family trust, you can specify in your ante-nuptial contract, when the time comes to calculate my accrual claim, any benefit that I have derived from my family trust must automatically be excluded. So it still forms part of your estate, but for purposes of this calculation, it is not included as part of the growth of your value. There are certain things which are automatically excluded in terms of the act, like anything that you inherit, any donations that is made to you, for example, and certain damages claims as well are excluded. Elmari, am I missing anything?
No, I think that's the most important things that you've mentioned. I know that the accrual can sometimes be quite a difficult thing to understand. And I think a lot of it is because people have different interpretations of the accrual. But I think the main thing that I want the listeners to get from this discussion is actually that the accrual is still a marriage out of community of property, and there's only a share if there is a growth, or if one of the parties' estate has shown any growth. And I want to just mention it a bit because the client who sent this email actually touched on it in the email, saying that you have to get married for love. Getting an ante-nuptial contract is not a good idea, then you don't really love the person. And I really wholeheartedly disagree with that. I do not agree with that at all. I think, yes, we definitely get married for love. But you do not enter into a business or whatever without having a contract, because you need protection. And that is exactly what we do with an ante-nuptial contract. And we do not necessarily protect one another from the other spouse. You don't protect yourself against the spouse. I don't know how to phrase it.
So
but
I would say you're saying that when you decide to get married, you already agree that you love one another. Then
Yes.
thereafter you decide, okay, we've agreed getting married. Now let's talk about how are we going to govern our matrimonial affairs.
Exactly.
It doesn't mean we don't love each other.
No.
If you say I don't love you, but at least I'm gonna get married with an ante-nuptial contract, then you
Yeah,
sit
then
with
it's a
with a whole nother issue. So
And
let's not get into that.
an ante-nuptial contract also protects clients from creditors, and it's not only protecting yourself when and if you get divorced, because when people get married, they don't want to think about a divorce. And I just want to mention that getting an ante-nuptial contract is not preparing for a divorce. You are preparing for whenever a marriage dissolves, at death as well. So that's important, because your marital regime also forms part and plays a major role when you pass away and with the winding up of an
With
estate.
that, the death aspect, it is important because I'm not sure if everyone knows it, but your executor's rumination is, for example, 3.5% on the value of your estate. Now, if you married in community of property, the husband passes away, I need to report the deceased estate to the master of the high court. I am going to report everything. Once again, if you have a bank account and only one spouse's salary has been paid into that, that gets reported as well, even though that partner or spouse is still alive. And your executor is saying, thank you, I'm taking my 3.5% on that. And if your executor is registered for VAT, he's taking VAT on the 3.5% as well. It's not included. So it's more expensive than to administer your deceased estate. You don't pay estate duty on that, but let's not go into too much depth for that. You touched on the creditors as well. 100%. We married in community of property. Now I do something and it doesn't work. There's COVID is a good example. It happened and my business venture unfortunately fails. Now the creditors wants to attach my assets. I cannot say only this is my assets because we have one joint estate. So from a legal point of view, they must attach the whole estate. So they're going to attach that bank account when you have always received your salary. So that's also something to keep in mind. It's not just preparing for a divorce. I wholeheartedly agree with you. Elmari, we didn't answer the question of which one should we choose? What's your preference when it comes to in out of community without the accrual?
My advice is definitely to get married out of community of property. The choice of getting married out of community of property with or without the accrual depends on the parties, and I think both are fine. If you get married young and you don't have a lot of assets and you really do want to share, if you are planning to build an estate, then I would advise get married with the accrual system. If you are already well set in your ways, you have a lot of assets, you've built a big estate, then I would advise get married out of community of property without the accrual system. But most definitely, I will never advise anyone to get married in community of property. The risk is just too high. It doesn't give enough protection. People must get married out of community of property.
I agree. When clients ask me the same question, remember, if you don't have an ante-nuptial contract, it's automatically deemed in community of property. So whenever clients come to see me for an ante-nuptial contract and they're asking my opinion, my advice is the same. You here, so it means you want to get out of community of property. I'm happy. Whether or not you include
depends on
the
the
accrual
party.
system or not, I'll explain to you how it works, but then that's your decision. And
Yeah.
I agree that if it is clients with a substantial estate already, then you will have to consider just getting married out of community of property without the accrual. So that it's not necessary for calculations and anything
Yeah.
later on. The spouses do not need to share. They've already built up their own respective estates. So yeah, with that regard, I agree. Another thing that I got asked the other day, Elmari, and I think it was a client that wanted to, well, they were busy talking about the divorce. They lost their ante-nuptial contract. Now, I
Yes.
know as a notary, I'm supposed to keep a copy of the original minute in my protocol, but that's not a registered ante-nuptial contract. So, of course, I said, well, go to the deeds office. They must have a copy. I'm not sure you practically deal with this. Is that,
I do.
hope I'm right.
So oftentimes people do lose their the original anti-nuptial contract, and what we usually do is we request a copy, but a copy for judicial purposes from the deeds office. So they don't issue a new original where the parties have to pay for it or whatever. They issue a copy, but it's used for judicial purposes. So it's a specific stamp on the copy, and the court is then willing to accept that copy. So we can proceed with that copy, but the copy is issued by the deeds office. Oftentimes, if people just want it for information purposes, they don't want to use it in court or for any official documents, then you can also get a Windeed copy. On the Windeed system, you can get a copy of your anti-nuptial contract. But like I said, that's only for information purposes. You cannot use it for any official purposes.
Yeah, I think what we didn't mention is your ante-nuptial contract gets registered in the deeds office, and that's why you can get a copy there. So they scan it, they save it on file, and it is registered against your name. Remember, it affects creditors, so it becomes a public document. That's why it's registered there. So if you go to ABSA and apply for credit and say, but I'm married out of community of property, they're going to want to see your ante-nuptial contract. And if they do a credit search, they can also pick up that it is registered in the Pretoria Deeds Office, for example. If you mentioned you had a beginning value of R1 million or whatever, it will show up in your ante-nuptial contract, except if you decided to do it in a different document. But yeah, once again, let me not get into that.
And I just want to mention, you can also change your marital regime. If you are not happy with the marital regime, or you were misinformed, or you actually thought you got married out of community of property but you didn't, or whatever the case may be, if there's good enough reason, you can actually bring an application in the High Court with the assistance of an attorney to then actually change your marital regime. Let's, for example, from in community of property to out of community of property. It's quite a process to follow, but that remedy is available to the listeners who got married with a marital regime that they do not really think is applicable in this circumstance.
But it's obviously much more expensive.
Right? Yeah, it is quite a costly exercise. So the best is to get married with the correct regime from the onset. But to our listeners who's already married, but they actually do want to change the regime, there is that remedy available. I also just want to make mention of customary marriages. Customary marriages are recognized marriages. It's legal marriages in South Africa, and people are often a bit misinformed. You also need an ante-nuptial contract if you are customarily married and you want marriage out of community of property. If you don't have a contract with a customary marriage, you are also automatically married in community of property. So when you start the negotiations with the family, when you start to, when you approach your bride, tell you want to get married, and you start the negotiations with the family, that's the best point to actually also go and see an attorney to get your ante-nuptial contract, because we must remember that an ante-nuptial contract must be signed before the marriage is concluded, and this is quite important with the customary marriages as well.
Yeah, I wanna jump onto this topic because I agree, and I've seen a lot of not unhappy clients but disappointed clients. They come and see me for an ante-nuptial contract because they've complied with all their customs. Now they just want to go and register the marriage 3-4 years later. And before they register it at Home Affairs, they quickly want to get their ante-nuptial contract, and I then need to be the bearer of bad news to say, but unfortunately, there is the Recognition of Customary Marriages Act, and as the name clearly says, it gives recognition to your customary marriage. So the moment you've complied with your customs, you are married, and it's given full recognition. It's in community of property. The fact that you have not yet registered doesn't render the marriage invalid. And then I specifically scroll to the section because clients don't believe me, and it says failure to register there's not an invalidity. It doesn't invalidate.
Yeah.
It's not a validity requirement. So yes, that's good advice. Please keep that in mind. There's case law that says if you only have agreed on your lobola and you have not yet paid it, it can also be deemed a valid customary marriage. So it's important with what you said. When you start with the negotiations, go and see your attorney already. Draft and sign your ante-nuptial contract. Then you know all is well, and you can continue and be married out of community of property.
Because the customs differ. And each family deals with a customary marriage in a different manner. And that's why it's always best when you decide you want to get married, before the negotiations or when you start the negotiations, to go see an attorney.
But I think to conclude, Elmari, I think we touched on everything. Our advice: get married out of community of property. And if you want to share in the assets, of course, the accrual system is there. And if you want to maybe discuss it a bit more with your attorneys, you're welcome to make an appointment. That's it from my side.
And please send us more questions if you have any, and like and subscribe our page. Thank you.